Early defense strategies pursued by former President Trump and the 18 defendants in Georgia are quickly complicating prosecutors' bid for a trial next month. District Attorney Fani Willis is trying to keep all the defendants together for a single trial that begins October 23. But the various legal maneuvers currently underway pose profound challenges to Willis' goal, which legal experts have described as extraordinarily ambitious. So far, 5 defendants have sought bring their charges to federal court, with 2 seeking a speedy trial and the majority seeking separate the charges from other defendants. Fulton County Superior Court Judge Scott McAfee described last week the challenges of trying so many people in such a short time. It seems a little unrealistic to think we can get all 19 done in 40 days, he said. Trump sought to delay trial deadlines in all 4 criminal cases, although charges in Georgia are not subject to presidential pardons. Latest maneuvers raise possibility that trial will not be held until after November 2024 election, while McAfee is expected to set a trial date for Trump in Georgia soon. Here's how his defense strategies play into that timeline so far. 5 of the 19 defendants are trying to move their charges from state court to federal court. It's a process called impeachment that could delay the case for months. The list so far includes 2 Trump administration officials, former White House Chief of Staff Mark Meadows and former Justice Department official Jeffrey Clark. 3 Trump supporters accused of signing documents purporting to be Georgia's valid electors are also engaged in this maneuver. Trump's lawyer suggested the former president could follow their lead. A federal judge rejected Meadows' motion on Friday, but Meadows quickly appealed the decision to the 11th U.S. Circuit Court of Appeals. The judge has not yet ruled on the others' requests. McAfee argued that the removals made it harder to achieve Willis' goal of trying all defendants in state court next month. Potentially optimistically, it might take a 6-month turnaround for the 11th Circuit to reach a decision. Right? McAfee said this at last week's hearing. Yes, sir. Assistant District Attorney Will Wooten responded. Even after 11th Circuit rules, losing party can prolong dispute by taking matter to Supreme Court. In the meantime, state court proceedings may continue. However, before a conviction is given, the defendant's request for dismissal must be rejected. Some legal experts believe that if any defendant's request is successful, the other's charges will automatically be moved as well. At hearing, McAfee questioned what would happen if the case was postponed after trial had begun. Where does this leave us in the middle of a jury trial? McAfee said, is there double jeopardy? Have you put your entire prosecution at risk now that this case has moved to federal court? And we were sworn in before a jury that presented evidence against all the othe.